Hello, welcome to the show. My name is Jacob Davidson. I'm a legal layman. I'm from North Texas, and it's a show where I learn the law and I try to educate while I learn. And welcome to it, everybody. Got a pretty simple topic today. Very simple. I'm going to be going over the articles of impeachment for Ken Paxton. And after that, I think I'll be listening to a little bit of the hearing that led to the impeachment. Because I think it's interesting to wonder where the mindset of the different legislative bodies landed whenever they decided to impeach the guy. But also, before I do that, I'm going to eat a rice cake, so, you know, deal with it. Where's locals? There you are. Live. Live now. Sneezing in his... I'll eat one for now and then worry about the rest of my appetite later. Do I have all my tags properly? I started here. Yeah, Ken Paxton and impeachment. Cool. Southern Anarchist, if you're not here to watch this mess, I'm going to be mad at you. Alright. Oh, fuck. That is rough. Just a moment, guys. Alright, so before we get started on the Paxton thing, since I'm probably going to get distracted and forget, before we do anything else, I must show you guys this cool thing. So, here is a steeper. And this is a kettle. But wait, there's more. There we are. About 5 teaspoons will do it. And the tea that I'm using is Sebastian's Morning Earl Grey. So in Sebastian's Morning Earl Grey into the kettle or the steeper. Okay. How the hell? Oh, there it is. Put the steeper back into the kettle, and then you put the fucking thing on. And now, following the instructions of boiling for 3 to 5 minutes, so I'll hit the fucking black tea button, and that'll be ready in 5 minutes. We'll talk about that later. Anyway, that's the tea. Use code Layman at Dragon's Treasure. Alright, but on to topic. Let's talk about Kim Paxton's impeachment. Here's the articles of impeachment that he got served with, and we'll read over it right now. Alright, so this article, House Resolution number 2377, by Murr A. Johnson of Harris, Garin, Longoria, and Spiller. Garin actually presides over my district. So, you know, it's nice to know that my my representative is impeaching a guy. Kind of cool. I don't know if he's good or not. It's just I tried talking to him once. Or rather, I called and I didn't get an answer. So, you know, suck a dick, Garin. Resolution. Be it resolved by the House of Representatives of the State of Texas that Warren Kenneth Paxton Jr., Attorney General of the State of Texas, is impeached, and that the following articles of impeachment is to be exhibited to the Texas Senate. Articles of impeachment. Exhibited by the House of Representatives of the State of Texas in the name of itself of all the people of the State of Texas against Warren Kenneth Paxton, Attorney General of the State of Texas, and maintenance and support of its impeachment against him. Article 1. Disregard of official duty. Protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as a public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Colemite Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mite Foundation in an effort to benefit Paul. Well, I guess as Paul is no apostle. Disregard of official duty, abuse of the opinion process while holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid an impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusions for the benefit of Paul. And this would be Texas subchapter. It would be subchapter 402. If the Attorney General is absent or unable to act, the Attorney General's first office assistant shall perform the duties of the Attorney General that are prescribed by law. Attorney General shall, at the request of an agency, designate one or more assistants to attend the meetings of the agency if the Attorney General served as an ex officio member of the governing board. Subchapter C. Here. A, B. For a case involving forfeiture, charter had heard on appeal before the courts. What subchapter? Yeah, whatever. Article 3. Disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his office as official power to minister the Public Information Law, Chapter 552, Government Code. I'm so glad they cite these things, because it makes it easy. Oh no. Oh no. If I hit 552 up here, would that actually give me the answers? Oh no, everything's threatening to close. Okay, there we go. 552. Hell yeah, I figured it out. Open government, policy construction. Oh wait, no, not here. Specifically, Paxton directed employees of his office to act contrary to the law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and application and applicable legal precedent. Article 4. Disregard of official duty, misuse of official information. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law. Chapter 552. Specifically, Paxton improperly obtained an access to information held by his office that had not been publicly disclosed for the purposes of providing the information to the benefit of Nate Paul. Article 5. Disregard of official duty, engagement of Kamek. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. Disregard of official duty, determination of whistleblowers. While holding office as Attorney General, Warren Kenneth Paxton violated duties of his office by terminating and taking adverse personal actions against employees of his office in violation of the state's whistleblower laws. 554 Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process, and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputation or prejudice their future employment. Article 7. Misapplication of public resources, whistleblower investigation and reports. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees whom Paxton had terminated to create and publish a lengthy written report containing false or misleading statements in Paxton's defense. The tea is ready. And I almost poured it onto my keyboard. That would have been great. All right, Article 8. Disregard of official duty settlement agreements. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees who Paxton had terminated. Specifically, Paxton entered into settlement agreements with the whistleblowers that provides for payments of the settlement from public funds. The settlement agreement stayed on the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Constitutional bribery. Paul's employment of mistress. Ooh, fancy. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Articles, oh yeah, that's Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the Office of the Attorney General. Article 10. Paul's providing renovations to Paxton home. Oh. This is constitutional bribery, yeah. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home, Paul receiving favorable legal assistance from or specialized access to the Office of the Attorney General. Exclusion from office for conviction of high crimes. Laws shall be made to exclude from office persons who have been convicted of bribery, perjury, forgery, or other high crimes. And bribery, in any case, is defined as any person who shall directly or indirectly offer, give, or promise any money or a thing of value, testimonial privilege, or personal advantage to an executive or judicial officer or member of the legislative or the member of the legislature to influence him in the performance of any of his public or official duties, shall be guilty of bribery and be punished in such manner shall provide by law. Any member of the legislature or executive or judicial officer shall solicit, demand, or receive or consent to receive directly or indirectly for himself or for another from any company, corporation, or person any money, employment, testimonial, reward, thing of value, or employment, or of personal advantage or promise thereof, for his vote or official influence, or for withholding the same, or with any understanding expressed or implied that his vote or official action shall be in any way influenced thereby, or who shall solicit, demand, and receive any such money or other advantage, matter, or thing aforesaid for another, as a consideration of his vote or official influence in consideration of the payment or promise of such payment or of such money, advantage, matter, or thing to another, shall be held guilty of bribery within the meaning of the Constitution, and shall incur the disability provided for said offenses with forfeiture of the office they may hold, and such other advantage, punishment as is or shall be provided by law. That's a lot to say. If you get money, thing, or stuff from somebody and you're the guy that has the power, you're screwed, boyo. Obstruction of justice. This is Article 11. Abuse of judicial process. While holding office as Attorney General, Warren Kenneth Paxton abused the judicial process to thwart justice. After Paxton was elected Attorney General, Paxton was indicted by Collin County Grand Jury for engaging in fraud or fraudulent practices in violation of the Securities Act and of Title 12 Government Code. Paxton then concealed the facts underlying his criminal charges from voters by causing protracted delay of the trial, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. You know, he might be right now that I'm only in one part. So I'm gonna read the rest of it before I jump into the thing. However, keep this whole election thing in mind. The whole Securities Act, the frauds after Paxton was elected. He might have been or indicted before this, though. Article 12. Obstructions of justice, abuse of judicial process. Paxton abused the judicial process to thwart justice. Yeah. I think two of these abusive... Yeah. Specifically, Paxton benefited from the filing of a lawsuit by Jeff Blackard, a donor to Paxton's campaign, that interfered with or disrupted payment of the prosecutors in a criminal securities fraud case against Paxton. Blackard's action caused protracted delay in criminal case against Paxton, including the delay of discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Article 13. False statements in official records, State Securities Board investigation. While holding office as Attorney General and prior to Warren Kenneth Paxton made false statements in official records to mislead both the public and public officials. Specifically, Paxton made false statements to the State Securities Board in connection with its investigation of his failure to register with the board as required by law. Article 14. False statements in official records, personal financial statements. While holding office as Attorney General and prior to Warren Kenneth Paxton made misrepresentations or false or misleading statements in official filings to mislead both the public and public officials. Specifically, Paxton failed to fully and accurately disclose his financial interests in his personal financial statements required by law to be filed with the Texas Ethics Commission in furtherance of the acts described in one or more articles. Article 15. False statements in official records, whistleblower response report. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in response to whistleblower allegations. Article 16. Conspiracy and attempt to conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Well, that really doesn't say much. That just says, wow, he thought about and he talked to people he thought about doing a thing against the articles. It's not very specific. Article 17, misappropriation of public resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services for his benefit and the benefit of others. Article 17, dereliction of duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oath of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described in one or more articles. Article 19, unfitness for office. While holding office as Attorney General, Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office as shown by the acts described in one or more articles. And finally, Article 20, abuse of public trust. While holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state as shown by the acts described in one or more articles. Oh, okay. My whole thing about, wow, it's very specific. So while holding off, Article 16, while holding office, that he conspired with, or attempted to conspire with, to commit acts described in one or more articles. Basically, all the articles above in this impeachment articles of impeachment, are what are being described, and this is basically saying, oh, and those, not only are those crimes in of them, or impeachable in of themselves, but they're also conspiracy and attempted conspiracy. So that's an additional charge to the charges. And finally, to the document prior. Accordingly, the House of Representatives of the state of Texas reserved to itself the prerogative of presenting at any future date further articles of impeachment against Warren Kenneth Paxton, of replying to an answer he makes to these articles, and of offering proof to sustain each of the above articles and to any other articles which may be preferred, requested that Warren Kenneth Paxton be called upon to answer these articles of impeachment in the Texas Senate, and that in those proceedings the examination, trials, and judgments be conducted and issued in accordance with law and justice. And those are the articles of impeachment against Warren Kenneth Paxton, the current Attorney General of the state of Texas. He has been taken out of power in the meantime. He has not removed, well, his powers have been removed. His title, I don't think they would remove his title until he's been properly impeached. And that would mean that the Texas Senate has found him guilty of these things. Basically, if anybody has any problems with all this, I just want to say, or I think I have an understanding of the process now. To put it in not government official state terms, the impeachment is a grand jury indictment, and the Senate hearing is the jury hearing for trial. House Committee of General Investigations. All right. So for anybody curious, I'm going to go over the Texas state constitution for impeachment processes. Board of pardons and paroles, parole laws, reprieves. In all criminal cases except treason and impeachment, the government shall have power after conviction and successful completion of a term of deferred adjudication, community supervision on the written signed recommendation and advice of the Board of Pardons and Paroles, or a majority thereof, to grant reprieves and commutations of punishments and pardons. Lieutenant Governor. This isn't a Attorney General, though, I don't think. In the case of temporary inability or temporary disqualification of the governor to serve, the impeachment of the governor, or the absence of the governor from the state, the lieutenant governor shall exercise powers and authority. Yeah. All right, deed of conveyance. Fuck. To the purchase for all lands and other properties thus sold shall be held to vest the good and perfect title and purchase, subject only to redemption as provided by the section, or impeachment for the actual fraud. Article 15, impeachment. This is where I should be. Impeachment by the House of Representatives. Section 1. The power of impeachment shall be vested in the House of Representatives. Trial and impeachment of certain officers by Senate. Impeachment of the governor, lieutenant governor, attorney general, commissioner of the General Land Office, comptroller, and judges of the Supreme Court, courts of appeals, and district courts shall be tried by the Senate. Impartial trial by Senate, concurrence of 2/3 required. When the Senate is sitting as a court of impeachment, the senators shall be on oath or affirmation impartially to try the party impeached, and no person shall be convicted without the concurrence of 2/3 of senator presence. Section 4 of impeachment merely states that the impeachment shall only remove and withhold them from office, nothing else. There's no criminal power to the impeachment. So here's a state in which Section 5 is the state in which Paxton currently resides. Section 5. Suspension pending impeachment. Provisional appointments. All officers against whom articles of impeachment may be preferred shall be suspended from the exercise of duties of their office. During the pendency of such impeachment, the governor may make a provisional appointment to fill the vacancy occasioned by the suspension of an officer until the decision on the impeachment. The language's provision of this provision is identical to the language of the official legislative measure originally. That's old wording, basically. All right. Removal of that doesn't apply. Section 6 because he's Attorney General. Removal of officers when mode not provided in Constitution. The legislature shall provide by law for the trial and removal from office of all officers of the state, the modes of which have not been provided in this Constitution. Removal of judges is Section 8. That does not apply. Section 9. Removal of public officer by appointing governor with advice and consent of the Senate. In addition to the other procedures provided by law for removal of public officers, The governor who appoints an officer may remove the officer with the advice and consent of 2/3 of the members of the Senate present. If the legislature is not in session when the governor desires to remove an officer, the governor shall call a special session of the Senate for consideration of the proposed removal. The session may not exceed 2 days in duration. And these are the articles of impeachment, or the article in the Constitution that give power and provisions for impeachment. So Paxton's been impeached. Here's what happens now. He goes to the Senate in an unspecified amount of time. I do not know the time frame in which he's going to be sent to the Senate. The Senate shall adjourn and then hear, or shall not adjourn, shall gather and will hear his case and then decide by 2/3 vote if he is to be removed from office and to prevent him from holding office ever again, or if they want to overturn the impeachment and say, Paxton, good boy. And I will go back to the articles of impeachment because I forgot to bring to light a certain point that I wanted to extract. Paxton made a tweet. Paxton. I'm beyond grateful to the support of millions of Texans who recognize that what we just witnessed is illegal, unethical, and profoundly unjust. I look forward to a quick resolution in the Texas Senate where I have full confidence the process will be fair and just. Well, he got impeached by a handful, like a vast handful of Republicans, so I'm not entirely sure it might go the way he thinks it does, or hopes it does. And I made a tweet. I was like, I mean, it might be unethical and unfounded, but as far as I've looked, I can't see it being illegal. Would anyone mind pointing to me the law that indicates so? I've gone over the Texas Constitution for this. If anyone knows where in the law this is, I'd greatly appreciate it. To which many people got very mad. This one in particular, for some reason was like, Trump supporters be like, show me proof that crimes are illegal. I'm literally asking if the guy has a proper claim. What the fuck? Wait, are you for or against Paxton? Jesus fuck. What is this guy's problem? Man. Fucking retards. Accusation includes dereliction, bribery, and unfitness for office. He filed frivolous lawsuits. So impeachment of taxes against Paxton. Yeah. Proof. Nice, 50% proof. Then it goes to a place of higher standard. So to the answer of my question, I found it here. Well, I didn't find it here. I actually tweeted it at somebody. Sections. Oop. So Paxton, yeah, I'm gonna go back to the tweet and read it. So yeah, unethical, illegal, unjust. So this process, what he refers to in what other people have told me, section 665.081. No removal for is, or rather, subchapter D, other removal provisions. No removal for acts committed before election to office. An officer in the state may not be removed from office for an act of the officer, for an act that the officer may have committed before the officer's election to office. The prohibitions against removal from office for an act of the officer commit for officer's election is covered by section 2102 local government code and chapter 8 local government code for aldermen of general law municipality and for so chapter 2202. There we are. References to municipal governing body and to members of municipal governing body. References in this code or any other statute. 1. A member of the governing body of a municipality includes each member of that body, regardless in the name, including alderman, commissioner, and council member, used by statute, municipal charter, or municipal ordinance to refer to the member. So the governing body of a municipality includes the municipal governing body, regardless of the name, including alderman. Yeah, it's basically the same thing. To the member and to the governing body itself. '87. And no removal prior, no to their election. So yeah, I guess it's a forgiveness clause. Yeah. Section or Article 16, I believe. If I remember right. That's 14, 15, 16. 17. No? Election? Paxton was elected Attorney General. Paxton was... So, if the claim is true that this happened after he was elected, Paxton was indicted by Collin County Grand Jury, his claim might be unfounded. Then what of Article 11? In which the accusation is after his election to office. To office of Attorney General. I'm still so confused by that one guy. It's like, I don't know what the fuck I did. Who bookmarked me? He was not allowed to defend himself in any court of law. You're allowed to defend yourself, otherwise people can just make up like what just happened. That's effectively what all prosecutors... Fuck, I am bad at spelling today. In almost every trial. At the grand jury level. This kind of has... It's a problem. But yeah. The only time Democrat or Republicans care about stuff like this is when the person is a Democrat. It shouldn't be a partisan issue. And thankfully for Texas House, they put politics aside and did the right thing. Hopefully the Senate will too. What the fuck? That's a lot of people. Nate! Nate the lawyer, is this how you feel? Okay. God damn! All I did was call into question his claim. Jesus, dude. So yeah, I've had a fun day. After this came out, I was like, well, Paxton, are you sure you're saying things right? Like, does he have to defend himself? Texas impeachment trial process. I made it. I'm about to step out for a few minutes, but I'll be right back. All right, see you back in a minute, NC Native. I'll check that out whenever I can. I got some new jokes for you. Oh god, I hope so. When I get back. Hell yeah. Uh, all right, so I think it is time to get into the impeachment video itself. Ignore that noise. I need to find it real quick though. So pardon me for a minute. All right, that's there. Uh, Sorry for the dead air. Just trying to find my stuff. All right, think I found it. Yeah. It's actually a goal. Hold on, I saw something. I'm probably gonna recover an old topic pretty soon. Do I need to wash my cup? That didn't taste good. I might need to cleanse my whole fucking setup. It's really good, I promise. There's something going wrong with my taste buds. Oh yeah, and I guess since we're at a point before I jump into this, the Dragon's Treasure is a haven for anime tea lovers, and you can now buy some coffee. I'm very eager to try out the coffee. He's already got two, which are for pre-order: the Dio with an exclamation mark and Demon's Extract. You can get everything from the Dragon's Treasure, all merchandise, all tea wares, all tea, all coffee, even the membership for 10% off with code Layman. So I highly recommend it. So you can get fantastic tasting tea and coffee with fantastic savings. So remember, code Layman for 10% off. Here is the Texas house. It's a 4-hour and 59-minute thing. This happened yesterday. Actually, I should go and see the Texas records. See if they've updated their website now. Broadcast archives. Nope. All right. Gonna drag it until we get some action going on. Ah. Oh dear God, this is pretentious. A prayer and a pledge of allegiance to the flag? Oh God. Religious services, guys. So they called into session the quorum, and after that, pledges of allegiance and prayers. Oh God. Yeah. What they just read in the video is what I read when I was like an hour earlier. That wasn't the question he asked, though. He asked, if I vote on Article 1, will that be construed as a vote on Articles 2 through 20? Dade, can you listen? I see what Nick means. I see what he means when he hates the process here. Hold on. I got someone I wanna like bring into this for a moment. Hey, hey, bro. When you're having a conversation with someone and you have a question, how do you ask your question? I'm learning in the House. It's a lot more frustrating than that. Basically, if you have a question, you have to ask personal inquiry for the House, and someone has to accept your question, and then you get to ask your question. Oh my god, I see the frustration now. Will Dave just answer the damn question? He's asking if I vote on one, do I vote on the rest at the same time? Jesus Christ, does Dave know how to hear? My god, he did not answer the question. How do you... Okay. I already hate this. I forgot. There we go.
Under Rule 5, Section...
Alright, so... Alright, thank you, NC Native. Thanks. I forgot to turn on the sound, as always. Alright, I'll count it down from the minutes. From 13 to 14 was prayers, and 14 was Pledge of Allegiance to the Texas flag. Minutes 20 through to 20... No, 31 were articles of impeachment.
That Warren Kenneth
Just read approximately 20
right.
parliamentary inquiry.
Please state your inquiry.
The clerk has just read approximately 20 articles. And my question is, will the House be asked to vote on each of these articles separately, or will it be asked to vote on all of the articles as a whole?
Mr. Smithy, under the resolution recently adopted by the House, we will vote one time on all articles of impeachment.
My question
That is a problem answer. It did not answer.
from a parliamentary inquiry.
Please state your inquiry.
My question is, if members of the House were convinced that there was sufficient evidence, if any, to indict under one count, would a vote for the resolution be construed as a vote to indict on other counts as well?
Mr. Smithy, the chair cannot speculate on members' personal perception on their vote for the resolution.
Mr. Speaker, a parliamentary inquiry.
Please state your inquiry.
Will each of the counts be laid out before the House separately, along with the evidence on each count, so that the House can make an informed decision as to each count of the indictment, or of the, of the impeachment resolution?
Under the resolution previously adopted by the House just now, we will begin that proceeding as soon as Mr. Murray is recognized.
Parliamentary inquiry.
Please state your inquiry.
With all respect, I don't think my question was answered.
Yeah, I think that's what was intended. Winner takes all. Take all votes. But the guy was trying to figure that out, and Dade just
That's
would
whether
not
we will have the opportunity
clarify.
to review the evidence that supports each specific ground separately, or if all of the evidence will be provided, and then we will have to sort out among ourselves which evidence pertains to which count.
Mr. Smithy, when we recognize Mr. Murr to lay out the resolution, I expect him to lay out each article as we go forward. Yes, sir.
Thank you, Mr. Speaker.
Members will have opportunities to comment on that. Mr. Canales, for
God, that frustrated the hell out of me. I don't mind so much if he wasn't gonna answer. I just hate the idea that he didn't understand, or he didn't get to the conclusion of the idea at hand. That bothers the hell out of me.
what purpose?
Alright, I guess hashtag in Paxton. Paxton. Impeachment. Texas Ledge. There we go. My first problem with Dade in the impeachment is that he simply didn't understand the first inquiry about if they would be voting on the articles separately or as a whole. That frustrates me, man. I cannot get over that.
Mr. Speaker, parliamentary inquiry.
Please take your inquiry.
Under Rule 5, Section 49, each member can also enter memorandums or comments as to their vote in those particular articles. For instance, Mr. Smithy is saying if we take a vote on all of it, but we're not convinced as to some articles, we would be able to make an entry into the journal as to the articles that perhaps we're not in agreement with.
You are correct, Mr. Canales. Each member has the right to place that statement in the journal.
Thank you.
Thank you.
It didn't resolve the answer or the question before, but it resolved it in a slight way. And so instead of the backing around and whatever, they just simply established, yeah, you have the right to leave a comment on any particular portion of the impeachment that you have a comment for. That doesn't cure the
The chair
problem.
recognizes Mr. Murr.
It doesn't cure the problem of the whole. Can we vote on a single article alone, please?
Mr. Speaker, members, we are going to do a layout, and then after our layout, it is our intention to certainly take questions, and so I'm going to defer each
I I have to do it to him. I have to do it to him. Oh, oh, fuck. Uh, doesn't doesn't he kind of look like a younger Jeff? Hey Danielle, it's nice to see you. Just want to say hello. I got to meet Gazi today. He's a cool person. In real life as he is in person. I hope you're doing well. I'm doing fantastic. I'm having a bit of a moment. I did not turn on the sound earlier, so I lost about like 10 minutes of content because I just didn't have sound, so I had to repeat it. But yeah, I'm about to try to go through 4 hours and 59 minutes of impeachment in about an hour and a half of time, and then I'll probably wrap it up the rest of it tomorrow because I got to go to work later. Because I find this to be very interesting. And hey Danielle, doesn't he look kind of like young Jeff? Oh, I hate doing this to him. I hate it. I hate it. I love it. I'm gonna post it on a comment to my own comment. Actually, no, I'm gonna post it separately. Hey, legal laces. Uh, any relations to this? Oh my god. Ah! Yeah, Vices, that's Jeff. I sent it to him. I sent it to him. Oh, that is fantastic. Wait, what? I saw something from Chandler Remington. Danielle, that is rough. A skinnier, younger version. He'd probably agree, but still, damn. Typically, but you know, he'll probably accept it and be like, yeah, you're right, you're right.
Each committee member will provide a portion of that information to you, and we'll begin with Speaker Guerin.
Oh, and
The chair recognizes Mr. Guerin.
And before he speaks, I just want to say, this gentleman right here, for information that would probably be too much for everybody else. I'm so surprised that the representative from my district currently is the one that was also the one that brought the charges. So, you know, that was interesting. This is my specific representative.
Thank you, Mr. Speaker. And members, before I get started, I'd like to bring to your attention that I put a letter on each of your desks that was composed by former member David Simpson called Honor and humility, and I would appreciate it if you would take the time to read that.
Oh yeah, on line cards.
Members, we're here today because the Attorney General asked the state legislature to fund a multi-million-dollar settlement against him brought by the whistleblowers. There was no investigation prior to this time. We wanted to look further into the reasons behind that. A whistleblower lawsuit was filed against the state of Texas in November of 2020, alleging that the Attorney General, Ken Paxton, wrongly fired employees for reporting their concerns that unlawful conduct by Mr. Paxton occurred. As members may know, under the Texas Government Code, Title 5, Chapter 554.002A, a state agency is prohibited from suspending or terminating the employment of public employees who reports a violation of law by another public employee in good faith to an appropriate law enforcement authority. This provision exists to protect individuals from retaliation and the public from illegal, unethical, and harmful actions of a state or local government entity, including elected officials of our state. What members should find notable about this case is the individuals involved. These whistleblowers included 4 of the most senior staffers serving under Ken Paxton at the Office of the Attorney General. They included a former DPS trooper and Texas Ranger serving as Director of Law Enforcement, Deputy Attorney General for Legal Counsel, Deputy Attorney General for Criminal Justice, and Deputy Attorney General for Policy and Strategy. These individuals were Republican civil servants who were, in many cases, recruited personally by the General to join the OAG. The individuals sought to advise him in the highest ethical standards that they had been staunchly loyal to General Paxton. While General Paxton has referred to these staff members as political employees, it is undisputed that these individuals were high-ranking senior staff members with years of legal and civil service experience and who had the highest level of access in the office of the OAG. Hardly political appointees, in my opinion. It is also undisputed that each of these individuals was fired after reporting General Paxton to law enforcement for concerns of bribery and abuse of office, among other issues. In February of this year, a settlement for the lawsuit was reached. As part of that settlement agreement, General Paxton agreed to, 1, apologize to the former employees for calling them rogue, publicly accept that these men acted as they thought was right, and agreed that the former employees would receive $3.3 million taxpayer dollars. This settlement served to stave off a trial, including the discovery process that could have brought new and important information to light. Because of this, neither the terminated employees nor the state of Texas were able to gain any more information about what transpired in that office. Most disturbingly, the settlement agreement was made without prior approval of funds and obligates the Texas taxpayers, not General Paxton, to pay $3.3 million for his actions. Of course, the Texas legislature would have to agree to payment of that settlement amount. Members, one of the key responsibilities of the General Investigating Committee is to look beyond partisan affiliation in order to take the necessary steps to protect the institution that is our state government. We do just that today with this resolution, and I would like to point out that several members of this House, while on the floor of this House doing the state business, received telephone calls from General Paxton personally, threatening them with political consequences in their next election. Thank you, members.
The chair recognizes Ms. Longoria.
Thank you, Mr. Speaker and members. The process undertaken by the General Investigation Committee and staff to better understand the settlement agreement and by extension any investigation into unethical actions by General Paxton
Oh wait, hold on. I got a thing. It was no, that's the Constitution. Ah, here's the minutes.
Paxton has maintained the highest standards of integrity and professionalism. The investigation began in mid-March and was led by a team of experienced state and federal prosecutors. Paxton has maintained undertaken by the General Investigation Committee and staff to better understand the settlement agreement and, by extension, any investigation into unethical actions by General Paxton has maintained the highest standards of integrity and professionalism. The investigation began in mid-March and was led by a team of experienced state and federal prosecutors, former public integrity unit leaders, and law enforcement personnel. Our chief counsel and committee director brought her experience as a public prosecutor, former assistant United States attorney for the Southern District of Texas, and federal prosecutor as her role as chief counsel. We had a career prosecutor with over 25 years of experience, including experience as a division chief of a public integrity unit in Texas, a seasoned attorney with 12 years as a federal prosecutor for the U.S. Attorney's Office for the Southern District of Texas. Another dedicated prosecutor whose experience includes being chief prosecutor for major fraud and public integrity matters. A former law enforcement captain with over 40 years of experience with high-profile complex cases, and an experienced criminal defense attorney with private investigator experience based out of Galveston County who's worked many high-profile cases. The General Investigating Committee requested this team of highly qualified professionals to conduct an inquiry into the whistleblower lawsuit settlement, issues related to the lawsuit, and to make an inquiry into the policies, procedures, and actions of the Office of the Attorney General, and specifically Mr. Paxton. While these individuals are known conservatives among legal circles, they are above all professionals with the requisite skills and experience to conduct an investigation of this magnitude and importance. This team was further tasked to ensure they maintained an independent and objective investigation, and was clear with all witnesses and stakeholders that the purview of the investigation was not tied only to the whistleblower settlement, but to the broader information sought on the policies, procedures, and actions of the OAG. The team methodically reviewed hundreds of records, including court filings, reports, past depositions, and related documents, including what is commonly known as the OAG report, concerning the Office of the Attorney General's own investigation into the actions alleged as a basis of the whistleblower's lawsuit. The OAG report, I will note, serves as Paxton's statement of defense to the allegations raised by the whistleblowers, and contains a multitude of statements that were disproved by our committee's investigation. And I think this is very important, members. Furthermore, the report was available on the OAG website at least as recently as May 23rd, the day before the committee's public hearing. It has since been removed. The team also OAG website, members. Furthermore, the report was available on the OAG website at least as recently as May 23rd, the day before the committee's public hearing. It has since been removed. The team also conducted 15 detailed interviews of individuals involved in these allegations to further determine a timeline of events and establish consistency in background information and facts. The research and investigatory findings by the attorneys, professional investigators that compose this team act as our basis of the articles of impeachment you see before here today. We ask you, as faithfully elected members of the Texas House, to consider the overall context of these findings to determine who benefited from these actions and whether a pattern of not just unethical, but possibly criminal action is found. Thank you.
The chair recognizes Mr. Spiller.
Thank you, Mr. Speaker. Members, in a public hearing on Wednesday, May 24th, the House General Investigating Committee heard approximately 3 hours of detailed, compelling testimony from a team of highly trained and experienced investigators, including multiple attorneys who had served as prosecutors specializing in white-collar crime and public integrity cases. The testimony reported facts relating to and supporting claims of multiple instances of misconduct committed by Attorney General Kim Paxton. You have been provided a transcript of that hearing and have had an opportunity to view and consider the video broadcast of the entire public hearing. Members, it is important to provide you with a concise summary of the pertinent facts brought forth in that hearing. In doing so, I intend to focus on what I believe is the primarily relevant, the matters demonstrating that Attorney General Paxton abused his office and his powers for personal gain. I will address several issues reported to our committee. First, let's visit about Nate Paul. Nate Paul is a real estate investor in Austin. Nate Paul was also a friend of Attorney General Paxton and a donor to Attorney General Paxton. Nate Paul had a real estate business, World Class Holdings. Nate Paul was in trouble with federal law enforcement. In August of 2019, FBI agents executed search warrants at Nate Paul's home and his business, World Class Holdings. Nate Paul owned and controlled World Class Holdings, and World Class Holdings controlled a number of other entities. In November of 2019, attorneys for Nate Paul made Public Information Act requests to the Texas State Securities Board for documents relating to the search warrants issued against Nate Paul and his businesses. The State Securities Board requested an Attorney General's opinion as to whether or not it was required to release the records. The Attorney General's office issues approximately 30 to 40,000 open records decisions each year. There is no evidence that Attorney General Paxton had ever taken a personal interest in any of those decisions except for this one that related to Nate Paul.
Whenever to toss salad, I always follow up with a big tip. Thought you were my OnlyFans girl. Oh, damn. Wait, why are you spending money on an OnlyFans girl? Why not spend some money on me? You're on Rumble, literally. Hold on, let me try this one out.
Although the requested information clearly fell within the law enforcement exception and would not have to be released, Attorney General Paxton pressured the OAG staff to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul. A highly unusual move that was contrary to well-established precedent relating to protecting the integrity of criminal investigations. Despite pressure,
I love how this lady right here is talking into her microphone. You can clearly see that she's got a sleeve mic.
Sure. The OAG issued a ruling that all records relating to the request were not subject to disclosure due to a pending criminal investigation of Nate Paul. In March of 2020, Nate Paul's lawyers tried again, this time making a Public Information Act request to the Texas Department of Public Safety for documents relating to the search warrants issued against Nate Paul and his businesses. DPS, you see, had cooperated with and assisted the FBI in the execution of the search warrants against Nate Paul. Because the search of Nate Paul's home and businesses was conducted by the FBI filed a brief with the OAG urging the OAG to follow its longstanding practice, policy, and procedure of not providing documents relative to an ongoing criminal investigation. A redacted version of that brief was sent to Nate Paul's attorneys, but Nate Paul wanted the unredacted version. And Attorney General Paxton tried to help him get it. DPS requested an Attorney General's opinion as to whether or not it was required to release the records. Again, Attorney General Paxton pressured a Deputy Attorney General to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul, including the unredacted FBI brief. Attorney General Paxton revealed that he had spoken personally with Nate Paul and told OAG staff that he didn't want to help the FBI or DPS in any way. Attorney General Paxton then took the entire file that had all of the responsive documents, including documents sealed by a federal court, and didn't return them for approximately 10 days. Attorney General Paxton then directed that the final opinion be issued and that the OAG take no position on whether the documents should be released. Then, in May of 2020, Nate Paul's lawyers made another Public Information Act request, this time to the OAG, seeking the unredacted FBI brief. Attorney General Paxton directed the same Deputy Attorney General to find a way to release it to Nate Paul and to draft an opinion authorizing the release. Attorney General Paxton then directed an aide to deliver a manila folder directly to Nate Paul at Nate Paul's place of business. The contents of the folder were never disclosed to OAG staff, and Nate Paul never followed up to attempt to compel production of the requested documents. Presumably, there was no need to. Next, let's talk about the Mitty Foundation. The Roy F. and Joanne Cole Mitty Foundation is a nonprofit corporation and charitable foundation located in Austin.
All right, hold on. So that's the Mitty Foundation. Yeah, I remember that. I called it Might Foundation because I was stupid. I mean, I'm still am, but still. Transcripts in Paxton evidence hearing. Uh, Damn, I thought there was gonna be like a transcript somewhere. Oh well.
Aside from performing a number of charitable purposes, it invested in and was a limited partner of several entities controlled by World Class Holdings, again, Nate Paul's company. The Mitty Foundation filed suit against several of those entities controlled by Nate Paul's World Class Holdings, claiming, among other things, that the Mitty Foundation was being denied access to the books and records of the companies, a right generally that every limited partner has. The litigation grew and later resulted in a court-appointed receiver being appointed over the entities. Now, the Financial Litigation and Charitable Trust Division of the OAG is entitled to receive notice of any litigation involving a charitable organization in the state of Texas. The OAG can intervene in such cases if the determination is made by the OAG that it's necessary in order to protect the assets of the charity. In January of 2020, after receiving notice of the pending litigation, OAG lawyers in the Charitable Trust Division filed a notice with the court declining to intervene in the case, a standard practice and reasonable under the circumstances since the Mitty Foundation was well represented by very capable counsel. However, in May or June of 2020, Attorney General Paxton began to take a deep personal interest in the case. The OAG has approximately 35,000 open civil cases each year, but this is the only one that Attorney General Paxton had ever taken a personal interest, the one involving Nate Paul. Attorney General Paxton had several discussions with the OAG staff about intervening in the case. Against the advice of the OAG staff and contrary to the OAG's prior determination not to intervene, Attorney General Paxton directed the Charitable Trust Division to intervene in the lawsuit. After intervening, Attorney General Paxton instructed a Deputy Attorney General to review the pleadings in the case. That Deputy Attorney General informed Attorney General Paxton that the OAG had no interest in the case, the OAG shouldn't waste its resources on the case, and that the parties in the case had already reached a $10.5 million settlement agreement, which Nate Paul subsequently breached. In other words, he defaulted on his obligation to pay the $10.5 million. The Deputy Attorney General strongly advised Attorney General Paxton to have nothing to do with Nate Paul and to get out of the case. So intense was Attorney General Paxton's desire to help Nate Paul in the case that he even suggested personally attending and appearing before the court, which would have been unprecedented. Attorney General Paxton directed OAG staff to file a motion to stay the case, in other words, stop the case, to force a mediation, a move which hurt the Mitty Foundation's position in the case and only helped Nate Paul's position, a position contrary to the best interest of the Mitty Foundation, to which the OAG's office had a fiduciary obligation due to its representation. Based on Attorney General Paxton's directives, the OAG attempted to force the Mitty Foundation to settle the case for about $5 million, less than half of the $10.5 million for which they had previously agreed to settle. The OAG subsequently withdrew from representation. The case moved forward, and the Mitty Foundation recovered a judgment for $21 million from a forced sale of some of Nate Paul's properties. Meanwhile, Nate Paul continued to have financial problems. 13 properties belonging to Nate Paul's business entities and to which Nate Paul was a personal guarantor were scheduled to be foreclosed upon on Tuesday, August 4th, 2020. Approximately 4 days before that, on Friday, July 31st, 2020, Attorney General Paxton contacted OAG staff to look into whether restrictions on in-person gatherings due to COVID could prevent foreclosure sales of properties.
Saw a Megalodon Jr. at a Trump
Attorney General
rally.
Paxton then made it clear that he wanted the OAG to issue an opinion by Sunday prior to the sale, stating that foreclosure sales could not be permitted to continue. That was contrary to established law, policies, and procedures, and that there was no written request for such an opinion from a qualified requester, and the time frame for responding to a request like that is typically about 180 days due to research, preparation, analysis, and review. When asked who requested the opinion, Attorney General Paxton gave no name, produced no letter requesting the opinion, and only gave staff a phone number which was incorrect. Attorney General Paxton was wanting the opinion letter done in 2 days, over the weekend. The opinion letter was prepared and issued, but was never published, as are other opinion letters. The effect of that opinion letter was used to thwart the foreclosures of Nate Paul's properties.
I'm so fat, if you were rolling me down a ski slope, the first person would yell snowball, but the second person would yell avalanche.
In May of 2020, Attorney General Paxton contacted the Travis County District Attorney and requested a meeting to help Nate Paul present a criminal complaint against federal and state law enforcement officials, prosecutors, and judges. The complaint was presented, but Nate Paul refused to swear to the truth of the allegations contained in the complaint. As expected, the Travis County District Attorney refused to have anything to do with an unsworn complaint and referred it to the OAG. Staff at the OAG investigated the claims and determined that no credible evidence existed to support any criminal charges. Attorney General Paxton, however, disagreed and insisted that a criminal investigation move forward. In August of 2020,
I know he's talking, but how much you want to bet that this lady right here is having a conversation with someone that's like literally like 7 paces the other way? Like, she's at this end of this like bench thing. I'm willing to bet at the other end of the bench, she's having like a full-blown conversation with someone over a microphone.
General Paxton sought OAG staff assistance in seeking outside counsel. That would have been a violation of OAG policies and procedures, and that the OAG seldom seeks outside counsel on criminal cases, due in large part to the fact that they've got approximately 800 assistant attorneys general on staff to handle criminal matters. But Attorney General Paxton was informed that the OAG's approval process for handling outside counsel requires authorization from at least 10 different OAG personnel throughout several stages, all designed, at least in part, to prevent the hiring of unqualified, conflicted lawyers. Further, the process is designed to be able to draft and approve a contract to make assessments, approvals for funding, and things of that nature. However, again, hiring outside counsel for a criminal case is seldom necessary. Attorney General Paxton later fought assistance on the ability to retain outside counsel to investigate criminal allegations. Attorney General Paxton was advised that Texas law only allows that in a couple of circumstances. One, if a prosecutor recuses himself or herself and the trial court appoints an attorney pro tem as a prosecuting attorney, or two, if a prosecuting attorney requests the assistance of the Attorney General and the Attorney General offers the prosecuting attorney the assistance of his office. Attorney General Paxton later informed OAG staff of his decision to retain Brandon Kamek, a criminal defense attorney who had been licensed only 5 years and had never served as a prosecutor. It was later disclosed that the source of the referral, where did Kamek come from?
Wait a minute.
Who had been licensed on Brandon. Attorney General Paxton later informed OAG staff of his decision to retain Brandon Kamek, a criminal defense attorney who had been licensed only 5 years and had never served as a prosecutor. It was later disclosed that the source of the referral, where did Kamek come from, was, of course, Nate Paul.
I mean, I kind of get why, but like, what's the big deal? He retained Banana Hammock. Like, he didn't serve as a prosecutor. That's fine. He's only been a defense lawyer for 5 years. I mean, that's also fine. Like, I kind of get it, but it's like, it's not a big deal. Yeah, if Jake Paul and Logan Paul were investors, were the sons of an investor, then there would be that strong tie.
Attorney General Paxton instructed OAG staff to draft an outside counsel contract and send it to Kamek immediately. Kamek approved the contract but didn't date it and began acting under the guise that he was approved by the OAG, although the contract had not yet been approved. OAG staff refused to approve the highly irregular contract. Attorney General Paxton continued to be involved, meeting with and pressuring staff to approve the contract. OAG staff continued to refuse to approve the contract and notified Attorney General Paxton that the contract was not yet approved. Despite this non-approval of the contract to retain Kamek, Attorney General Paxton instructed Kamek to begin work. The contract was never approved. The contract, even if it would have been approved, did not identify Kamek as a prosecutor. It specifically stated that Kamek was not to provide indictment or prosecution legal services. Despite this, at the instruction of Attorney General Paxton, Kamek proceeded to conduct work and falsely represent himself as a special prosecutor in order to obtain 39 grand jury subpoenas directed to Nate Paul's adversaries relative to the Nate Paul complaint, which were directed to the very law enforcement agencies and entities contained and specific documents referred to in the FBI unredacted brief that Nate Paul was never to have received a copy or access. The parties and information contained in the subpoenas would not have been knowable unless someone had access to the unredacted FBI brief. The subpoenas were signed by Kamek as special prosecutor. Further, Nate Paul's lawyers accompanied Kamek when serving one or more of the OAG subpoenas. All of these actions were taken under the instruction, involvement, and approval of Attorney General Paxton. When the OAG staff learned of the issuance and service of the subpoenas, they had them quashed or canceled. In summary, what I've outlined to you is not an exhaustive list of the claims and issues presented to our committee. It is, however, a compelling substantiation of the fact that Attorney General Paxton abused his office and his powers for personal gain. Attorney General Paxton continuously and blatantly violated laws, rules, policies, and procedures, improperly and illegally using OAG staff, resources, and monies to intervene and interfere in the civil disputes and criminal matters of his donor and friend, Nate Paul, and benefiting himself. Members, I remind you that your function in this process is to act somewhat in the capacity of a grand jury. An impeachment is similar to a criminal indictment and must be followed by a trial in the Senate. You don't have to have proof of anything beyond a reasonable doubt or by a preponderance of the evidence.
Not even.
The House decides only if there is sufficient evidence to justify further legal proceedings. Today is a very grim and difficult day for this House and for the state of Texas. Attorney General Paxton has a brilliant legal mind and has worked diligently for the state of Texas. I have great appreciation and respect for the many, many things that he has done for this state. Frankly, Attorney General Paxton deserves praise for his fierce, consistent efforts to push back on behalf of Texas against unconstitutional federal mandates, executive orders, rules, and laws. But members, no one person should be above the law, least not the top law enforcement official of the state of Texas. We each took an oath of office. Attorney General Paxton took an oath of office. He violated that oath. He put the interests of himself above the laws of the state of Texas. He put the interests of himself over the established laws, policies, and procedures of the Office of the Attorney General. He put the interest of himself over his staff, who tried to advise him on multiple occasions that he was about to violate the law. He put the interest of himself over the top officials in the Office of the Attorney General that he fired and retaliated against for reporting in good faith their belief that he violated the law. He put the interest of himself over the lawful functions of the FBI, the DPS, and other law enforcement agencies and prosecutors in their attempts to investigate and prosecute criminal activity.
Well, I mean, to his credit, I would also oppose the FBI if it were to investigate me as much as I could, in a way. Because, you know, fuck the FBI. They can go fuck themselves.
He put the interest of himself over the taxpayers, whom he asked to foot the bill for millions of dollars to pay for his illegal activity and to pay for his personal interest, all without having to answer any questions under oath about his activities and actions. And he put the interest of himself over the citizens of the state of Texas. Members, it brings me no pleasure to be standing here today in front of you dealing with this matter. I know that it's not pleasant for you either. But we have a duty and an obligation to protect the citizens of Texas from elected officials that abuse their office and their power for personal gain. As a body, we should not be complicit in allowing that behavior. We should not ignore it and pretend it didn't happen. Texas is better than that. Thank you, members.
I guess if there was a court document, what that man just presented would be the introduction of facts. Here are the reasons. Here's the narrative of our charge. So Gizly always has her panties in a bunching. I kind of get the Smitty's question at the very start where he's like, will we be able to vote on these charges separately? And it's like, I mean, even if you could, but you still have to vote yes or no. So even if you impeach on one, that's still an impeachment all the way through. So I guess that would reduce the amount of impeachable impeached charges that would go to the Senate. So they would, I guess the idea was they could whittle down like the 20 into like 5 or something like that if they just didn't agree entirely. It's a Tom Brady joke. Oh, okay.
Without objection, members, Ms. Ann Johnson will make the final opening statement. Her time will not affect the time allocated for questions. The chair recognizes Ms. Johnson Harris.
Thank you, Mr. Speaker. The last 72 hours has shown us why Ken Paxton is so desperate to keep his case in the court of public opinion. Because he has no ability to win in a court of law. See, in a court of law, a judge will preside over that case and he will be treated just as any other civil or criminal defendant. Witnesses will be under oath for all the world.
And in that case, lady, the criminally indicted individual or the individual being indicted would be treated with the utmost fairness, and their rights would be the most protected by the judge because they are the accused of an act. Like, I get what she, like, it's kind of alright what she's saying, but it's like, kind of sucks. She's trying to like go this whole, it'll be fair, but it's like, yeah, but the judge will have to defend the defendant properly.
World to see. And this past Wednesday, 2 investigators and 4 career prosecutors with decades of work in public integrity and white-collar crime revealed that they had confidentially been interviewing witnesses and reviewing evidence into Attorney General Ken Paxton for months. Public integrity means looking into and prosecuting elected officials who have used their office for their own gain. This body, we, have passed numerous laws to protect the public from corrupt officials, like abuse of official capacity, official oppression, misuse of official information, bribery, and corrupt influence, all of which we have here. White-collar crime, not your pickpocket, the use of complex systems that can destroy companies, wipe out people's life savings, cost investors millions of dollars, and erode the public trust in institutions.
Wait, why do we care about investors' millions of dollars? They can go fuck themselves.
Crimes like mortgage fraud and securities fraud. These are not new concepts to the committee's investigative team, but their discovery that the state's top cop is on the take was and is extraordinary. Criminals have an MO, a modus operandi, a method of operation, just like any common theme of a thief, a rapist, a murderer, where they have patterns that can develop over time. And Paxton has shown over time he has a power in his ability to not respond until caught. Once he has learned he is caught, he will often lean on political friends, delay the process he could to avoid the courtroom, and lie to the public for almost a decade, thinking his reelection served as the ultimate get-out-of-jail-free card. We sit here to judge like any other grand jury to decide whether or not we want to move forward. And criminals rarely confess.
See you later, NC Native.
That is why we don't have to
You can
prove
call me
motive,
Jacob, that's my name.
and we don't have to prove cases in any other way than ideas such as circumstantial evidence. And so let me explain circumstantial evidence. We have all been in the grocery store, and I want you to imagine that you turn down the aisle, and as you start down the aisle, you see another person coming the other way. They're pushing their buggy. They've got a child sitting there in the top of it. They're reaching up for items. They're looking down at their list. And as you get to each other, oh, I'm so sorry. Are you okay? I didn't mean to hit you. Do you think that they meant to hit us? You can see all the circumstantial evidence around it and say, I don't think they meant to hit us. Now let's take that we turn down the aisle, and on the other end of the aisle there's a cart coming, a person pushing, no distractions, no baby, no list, and they're coming right for us. And we move over the other way. and they come in our lane, and we move over the other way, and boom, I'm sorry, I didn't mean to hit you. Do you believe that?
I don't think that's what circumstantial evidence means. I don't think that's a good example of it, but sure, that's fine, lady.
It's the same analysis that we go through in looking at an entire timeline when determining criminal activity. We also are not required, when a potential offender tells us a statement, that we have to take them at their word. We look and we are responsible for evaluating and looking at all the circumstances. And so let's take a look at what's happening with Texas Attorney General Ken Paxton. It's around October 2020, and the office is beginning to scramble in a crisis. Calls are starting to come in because there are agencies and entities receiving subpoenas that they are wondering, what in the hell are you doing? Are you really looking for this kind of information? At that point, they are aware that there are more than 30 subpoenas that have gone out to banks, asking for loan information, checking and saving account information, personal cell phone data of bankers, investigators, and a judge. They begin to recognize that these subpoenas are supposedly authorized by Brandon Kamick. Who the heck is that? You have these entities of operations of men who have been in different silos who all come together, and they all, at that point, sitting around with each other, realize that there is a common thread that they are hearing, and they all perk up. They realize the conduct that the Attorney General has independently been committing with each of them over a course of a number of months. All roads lead to Nate Paul. All of them recognize through their own independent discussions with the Attorney General, they have warned him, Nate Paul is no good. You can do a common Google search and see his bankruptcies, and there is no way you should have anything to do with him, and there is no way this office can participate in anything on his behalf.
I will have to say, these first couple opening arguments have been very compelling. I have been thinking that maybe Paxton is either an idiot or like a criminal. But yeah, very compelling so far. I've been very interested in their grand jury claim.
Article 1. When Ken Paxton asked the Office of the Attorney General to interfere in the Mitty Foundation, as Representative Spiller has spelled out, he turned the Attorney General's office against a nonprofit. As the lawyers for that nonprofit said, quote, they felt ominous pressure, being forced to attempt to settle on the cheap to the benefit of Nate Paul. When the Office of the Attorney General suggested that they settle for $5 million when they had a $10.5 million already recognition of Nate Paul was supposed to provide, and then later being recognized that the value of that case to them was $21 million. You heard from Representative Spiller that unusually Ken Paxton involved himself in these manners in a way he had never before done with regard to a charitable entity. He broke the fundamental rule that this body has passed to say that the Attorney General will protect nonprofits for the interest of the vulnerability of all Texans. And in this case, he turned that on his head, represented his friend, and he broke the law. This article represents abuse of official capacity, which is a third-degree felony warranting 2 to 10 years in prison. Article 2, when Ken Paxton asked the Office of the Attorney General, as Representative Spiller just displayed, what they called the midnight opinion. Nate Paul has 13 properties that are in foreclosure, and they know that he has one or more set, or he knows that he has one or more set this next Tuesday. They go scrambling, and they originally write an order that says there is no need for us to shut down. Ken Paxton says no, do it the other way. They acknowledge to him and say, you do get that we're going to say that while it's COVID, that 10 people can't get together outside for foreclosure, and that goes against every other policy that was being issued at the time by the state with regard to COVID. They issue it anyway. When Nate Paul is deposed and he is asked, did you have contact with Attorney General Ken Paxton before that order was done? Quote, yes, I had contact with him before that, end quote. Ken Paxton, he broke the law. This is misuse of official information, another third-degree felony warranting another 2 to 10 years in a prison. Article 5. When Ken Paxton sets up this rare lunch, he asks the Travis County DA's office to sit down and meet with Nate Paul. He makes a personal introduction. As a courtesy, the Travis County DA stays. They listen to Nate Paul and they think, there is nothing here for us to do to investigate. He insists that he wants them to try to help him because he believes that he has been falsely accused and needs to get access to information with regard to the FBI. They require that you give a sworn statement. And the reason they want you to give a sworn statement is you want to try to prevent people from using law enforcement agencies for false and vindictive purposes. He doesn't give a sworn statement. Travis County says, nothing for us to do here. There is no there there. There's no case there. Ken Paxton then assigns Mark Penley, Deputy AG, and David Maxwell, the Director of Law Enforcement, to meet with Nate Paul and to meet with him. They again tell Ken Paxton, quote, no evidence of a crime and no state interest, end quote, is here. There is no reason for us to get involved or have anything to do with this guy or his allegation that the federal government has tampered with him. Ken Paxton insists, do it again. At this point, Nate Paul comes back and he has some records that he suggests have been tampered. The Attorney General's office then has an expert go through the point of doing analysis on the document and again comes back and says, there's nothing wrong here. This document has not been tampered with. Ken Paxton says, I just need you guys to meet with Nate Paul and tell him. They again sit down in a room with Nate Paul, Ken Paxton, and these senior officials, and they say, look, there's nothing here that this office can do for you in this circumstance. They describe that Nate Paul gets, quote, incensed, end quote, and, quote, dresses them down, senior staff, like they were his employees, end quote. These two men for decades say, we're not getting involved, we're not doing this. As Representative Spiller said, there are some 800 lawyers that can engage in criminal issues. Ken Paxton, Freudian slip, decides that he's not going to let it go. Ken Paxton is going to now look at two different individuals to hire to act as a special prosecutor, one of which is decorated decades of experience in prosecutorial experience, and the other is a 5-year lawyer, defense attorney, and never been a prosecutor. Guess which one gets hired? The guy that's got no prosecutorial experience, and it's because he comes at the recommendation of the attorney who works for Nate Paul. Ken Paxton sets aside money for this young individual to work, and he tells Penley that he needs to hire him. Penley refuses and will not sign the contract. He says no. Ken Paxton again asks on a Saturday, come meet me, I want to talk with you. They meet in McKinney, and when they do, Penley again warns Ken Paxton, quote, you are exposing yourself to potential criminal liability, end quote. He says, do not do this. And Ken Paxton says, you got to sign the contract. He's been working for 2 weeks. He needs to get paid. Penley then says, fire him. I will not participate and I will not supervise this guy. And Ken Paxton responds, quote, don't worry, I will, end quote. The grand jury subpoenas that are put out include bank records, individuals, and contacts, as already recognized with regard to investigators and a judge in a case involved with Nate Paul. This raises serious questions about the release of public information. It raises serious questions about exposing a search warrant. And why do we have search warrants and why do we redact them? Because we appreciate law enforcement. We appreciate those witnesses that will come forward in the interest of justice, and we do not turn over those files to a target, because what can happen? Witnesses can be tampered with and evidence can go missing. It is a fundamental tenet of offices of prosecution and law enforcement that you do not expose those individuals. But as Representative Spiller has already indicated, there is a correlation between the access of that unredacted file and Ken Paxton to Nate Paul, and sure enough, it is those individuals and their information that's being sought in this warrant. One of those investigators later goes to get his car fixed, and when they get the car fixed, you know how they raise it up? He says, "Hey, can I take a look underneath?" and finds a tracker, and finds that that tracker has been active and searching, and it's been on around the time that these things start happening. Ken Paxton broke the law.
Wait, why use a tracker when you could just subpoena for Google for the information? They'll just give it to you hand over fist. I mean, it's still wrong, but it's like they could have been smarter about it.
Appropriation of fiducial property, which is a state jail felony, carrying 6 months to 2 years, and another case of bribery, carrying a second-degree felony of 2 to 20 years, and abuse of official capacity, another third-degree felony, carrying a punishment range of 2 to 10 years. Article 3 and Article 4, when Ken Paxton asked that they issue this no decision, when you have the receipt of the manila folder that he has for 7 to 10 days, when we know, like any other criminal who wants to cover his tracks, he doesn't hand it to Paul himself. He gets a young aide, gives him the package, and asks him to deliver it to Nate Paul at one of his Austin businesses. Ken Paxton, again, broke the law. Misuse of official information, abuse of official capacity, again, an additional third-degree felony warranting 2 to 10 years in prison. When these whistleblowers, these individuals find out what's happening, they begin desperately to start cleaning up Ken Paxton's mess. They recognize that those 39 grand jury subpoenas that go out, and let me explain how this happens. The Attorney General typically will assist in other counties. So it is not unusual that they went to Travis County and they said, "I need to issue these grand jury subpoenas." A grand jury subpoena carries weight. It means you must comply, and if you don't, you're in violation of the law. It was issued by, quote, Special Prosecutor Brandon Kamek, and it was signed by a judge. It is the Attorney General's office themselves, these entities, these individuals who started to see when it boiled over and realized what was happening around Nate Paul, that they go file motions to quash. A motion to quash means I'm telling you, you no longer have to respond to this order, and in doing so, they say that the individual that had submitted them did not have the authorization and should not have done it, and they should not comply with that response. Articles 9 and 10. Articles 9 and 10 relate to the issues of the affair and the renovations. Why is the affair important? The affair is important because it goes to Ken Paxton's political strength. He knows that with his folks, he is family values. He is a Christian man, and the idea of the exposure of the affair will risk him with his base. In fact, when the affair comes out, there are a couple of people in the office that say, "I can't work for you, and I'm leaving." He has an interest in attempting to keep this affair quiet. He also has an interest in continuing it. Another staff member says that he comes to them distraught of how he is continuing to be in love, and she tells him, "What the heck are you doing? You are exposing yourself, and you are exposing this office to potential blackmail and potential influence, and you can't do it. The other benefit is that Nate Paul giving his mistress a job means that he no longer has to drive back and forth from San Antonio to see her, and it makes her more convenient and here in Austin. With the renovations, you may have heard part of the story with the renovations is that they have a home here in Austin that is undergoing floor-to-ceiling renovations. The idea of this is that there is a young man with Ken Paxton. He normally has a security detail, but he starts doing things without that detail, and he starts doing things that are not on his schedule. One of those things is going to this renovation house, of which there is a disturbing encounter. This young man realizes that as they are standing there in the home, and Ken Paxton says, hey, we want to change out these countertops and get something else. And they say, that's going to be like $20,000. That's all right, go for it. The contractor says, I'll have to talk to Nate. This young man is disturbed by it. In fact, he's crushed by it. He believes Ken Paxton is one of his heroes. He is a leader of...
Huh? No, not yet. There's a opening statement that's being played. There's an opening statement that I'm hearing.
The Republican Party, and he is the Attorney General. This young man is bothered by it enough that he eventually asks him and says, hey, what was the deal with that? And this young man does not get an answer of which satisfies him. The whistleblowers now come forward and disclose their information. It is after that that this young man is offered a promotion. He declines, and he leaves the office. After he leaves the office, he continues to get a stipend and a check from Ken Paxton's campaign for $250 a month. He calls repeatedly, says, I don't want this money, please stop it. It goes on for about 4 months. At the point in time that it finally stops, he writes a check and he sends it back to the campaign without anybody knowing about it. This is the kind of integrity of the people that we describe when we say that the committee investigators have met with more than 15 people, many of them Republicans, many of them who worked in the office as civil servants, and many of them deeply conflicted about the information about what they had to disclose and the individual, because each of them, almost to a fault, attempted to remain loyal and help Ken Paxton. In these 2 articles, again, Ken Paxton, he broke the law. He received an improper gift to a public servant, a Class A misdemeanor carrying up to a year in a local jail. He again has the appearance of bribery, a second-degree felony. You all get to judge, like that cart coming down the aisle. Are these just individual isolated incidents of which you can dismiss, or are they an unexplainable pattern of ongoing criminal conduct? Articles 12, 13, 14, and 16, these relate to the underlying securities fraud, failure to properly disclose and register. And I think that Speaker Guerin said it best in our hearing if you were watching, because at one point there was a discussion about a $100,000 gift given to Ken Paxton. And the issue was the fact that he originally did not disclose it as a securities operator to say, hey, I have a vested interest in what I'm getting, and it's either an improper donation and disclosure, of which he is aware of the laws and obligations for transparency, and when he gets busted on that, he says, no, it's just a gift. And somebody says, what do you mean it's a gift? And he says, I met a guy in a Dairy Queen, and he told me God told me to give you this $100,000. Speaker Guerin said it really well. I have never had anybody come up to me and said, God told me that I should give you $100,000. That's not the only $100,000 incident. There is another $100,000 gift, which is a donation to his legal defense fund, and there is another questionable securities issue gift with regard to the Maori Corporation. We see, like in those circumstances, that it is his opportunity to delay, and extend the court proceedings that keep him from never having to go to court. We bring those incidents to you to look at that whole aisle, to determine the course of conduct that he has set in motion for almost a decade. Is that part of his MO? It is when he gets caught in those circumstances that he will say, oh no, I'm sorry, I forgot, I didn't realize, I should have registered it this other way. There are probably a lot of folks in here that speed. You may have a lead foot. And I now want you to think about how many tickets you've gotten, because you've spent a whole lot more than you've been caught. And these are 3 instances of payments of large amounts of cash to a man that he did not attempt to correct until busted. Articles 6, 7, and 8 deal with the whistleblowers. These individuals who were doing everything.
Oh God, she's only on Article 6. God damn it. I kind of got lost in it all, really.
Everything they could on behalf of the state of Texas and everything they could on behalf of that office, they were fired. They were not only fired, they were shamed. It stained their reputation and it stained their careers as great public servants and law enforcement officers in an attempt for Ken Paxton to save his own skin. Through this investigation, those individuals have been talked to, but I will tell you there are others. There are those that are not yet brave enough to come forward, and we won't judge them. Because it's almost like, why would you? This guy has gone almost a decade manipulating the processes, throwing false narratives out, and almost proving himself to be untouchable. We see that same MO starting now. Complaints of process, and I haven't gotten to tell my story. This is his story. This document, almost 400 pages, was sitting on his website for years. This is his answer to the whistleblower's complaint. This document went missing after we said, don't do anything with any of the evidence in this case, and you are currently under investigation. I guess it is hard to walk into a committee and claim nobody has asked you any questions or looked at process if this sucker's still sitting on your website. It is gone, and it is illogical that somebody wouldn't have realized that we would have printed out a copy. Not only did we print out a copy, but the committee investigators reviewed this report, and in the hearing, you can start on page 124, line 10, and you can go all the way to 130:19, where the investigators say not only did we review everything and talk to the witnesses involved and looked at the evidence, but page 46, false claim. Page 5, false claim. Again, page 5, false claim. Page 49, false. Page 5, misleading. Page 49, false. Page 50, false. Page 6, false. Pages 5 and 6, false. Page 42, false. Page 52, false. Page 7, misleading. Page 39, false. Page 39, again, false. Page 39, false. Page 39, false. Again, accusation, false. Accusation, false. Accusation, false. Page 34, false. And then asked, do you want me to keep going? Please. False. Page 52, false. Page 56, false. Shockingly or not shockingly, Ken Paxton's office investigation into whether or not Ken Paxton committed his own crimes has been and recognized to be repeatedly false. Again, with regard to the whistleblowers, Ken Paxton, he broke the law. Retaliation under our government code is a felony of the 3rd degree carrying another 2 to 10 years in prison. Official oppression is a Class A misdemeanor warning a year in a local county jail, and the government code 55.4.002 of the whistleblower statute and civil penalties. Articles 16, 17, and 18 go to the ideas that this gentleman is no longer fit for service or for office, that what he has done has impugned the integrity of our court system and those who have worked very hard to keep it functioning. We asked a question to the committee investigators about what they found about those whistleblowers and the courage that they demonstrated. Quote, "The thing that I think struck all of us in our investigation, not only in speaking with whistleblowers, but other high-ranking officials at the Attorney General's office, is that these are individuals who are extremely well-credentialed and qualified. These are individuals who had taken upon their role as public servants to do their oath. Is what their oath asks them to do, to uphold the laws of the state of Texas and to uphold the Constitution. Many of the people that we spoke with, specifically some of the whistleblowers, are known outside of the office of the Attorney General's circle. They are well-respected former law enforcement. They are well-respected attorneys. They're individuals who are considered subject matter experts in the field, and they are oftentimes the cream of the crop. They rose to the positions that they are in because of their work ethic and because of their dedication. And the feeling was shared almost universally that the actions that they were being asked to take, the positions that they were being put in, and the decisions made by the Attorney General sullied their office and sullied their commitment and their careers. I've had the opportunity to work in criminal courts for almost 20 years, and I feel for you in the same way that I feel for jurors. Nobody asked to have to be brought in to make these judgments. But I will say it is not you who asked to be here, but it is the person who continually broke the law. And that man is Kenneth Paxton. This story now comes to the fork in the road for all of us. And either this is going to be the beginning of the end of his criminal reign, or God help us with the harms that will come to all Texans if he is allowed to stay the top cop on the take. If millions of Texans can't trust us to do the right thing right here, right now, then what are we here for?
And I believe that is the opening
The chair
statement
recognizes Mr. Murr.
from the lady. Yeah, I hate that.
Members, you've heard about the whistleblower lawsuit. You've heard about the work performed by the General Investigating Committee. You've received a summary of the facts and an explanation of the charges outlined in the articles. Mr. Speaker, I believe we're now ready and willing to take any questions that any members have.
Mr. Schaefer, for what purpose?
Will the gentleman yield for some questions?
The gentleman yield for questions.
Yes.
The gentleman yields.
Thank you, Chairman Murr. In your role as a member of the General Investigations Committee, did you interview any witnesses?
The only difference from this between a grand jury indictment is that the grand jury, I don't think, gets to ask questions. However, in this certain circumstance, with an impeachment, you can ask questions. I do believe that is the differences here.
As part of the investigation of Attorney General Paxton.
So what is
Your role?
Yield for questions.
Yes.
The gentleman yields.
Thank you, Chairman Murr. In your role as a member of the General Investigations Committee, did you interview any witnesses as part of the investigation of Attorney General Paxton?
As you heard during our explanation, when we learned about the request for multi-million-dollar payment of settlement back in February, the General Investigating Committee undertook the efforts to hire highly qualified, experienced attorneys and investigators to perform those interviews for us and then report that information back to the committee.
Did you interview any witnesses?
As I explained, the folks that we hired to work for the committee did the interviewing.
Did any member of the General Investigations Committee cross-examine a witness?
As I've just explained to you, we hired long, skilled, and qualified attorneys.
That's kind of a problem, I would say. I think that might be a bit of a problem for their whole case. It's not the biggest detriment, but if, you know, the people involved in the general investigations decided to offload the work to a third party, it might be a little suspect, at least, I would say.
Attorneys and investigators to do that work for us. And it was conducted in a very professional manner. Each of those investigators
But like, he's just asking questions, say yes or no. It's not like if you say yes or no to the question, it suddenly hurts your case. Someone will probably ask if you don't need to address the problem that's not there. You're making the problem for yourself there.
Investigations and interviews involved the attorneys for the witnesses, including the whistleblowers.
Chairman Murr, are you aware of any member of the Texas House of Representatives who was given an opportunity to interview witnesses?
So I'm gonna answer that in a broad stroke because I understand that you're trying to make a point, but what I'll tell you is this originated with the request for $3.3 million, and that started back in February.
I get the point. Politicians speak and politicians speak. It's so annoying. Why so combative on the answer, though?
February, when we understood that a settlement agreement had been reached by parties in that litigation.
I understand.
I'll finish. At that time, Mr. Paxton and members from his office actually appeared before an appropriations subcommittee and requested payment of funds, but declined to answer questions as to what happened in the lawsuit.
Chairman Murr, do you know whether any witnesses that spoke to the investigators hired by the committee were placed under oath?
No witnesses were placed under oath, analogous to any investigation that you would have into criminal activity. Typically, you do not see law enforcement or investigators place a victim or a witness under oath. That occurrence occurs at a trial. And
no, you get a signed affidavit from the witness that basically makes an under oath statement. Murr, what are you going on about? None of the statements that they got were under oath. They're questionable at best. All right, you know what? I'm probably going to find a prosecutor in Fort Worth. Ask them about a signed affidavit before going to a grand jury. If anybody can find me a prosecutor in Texas, I would be happy to ask them this question.
As you're well aware, and we issued a memo explaining the process of impeachment, this is not the body that does the fact-finding. The fact-finding occurs in the Senate, and the oath for any witness would occur there.
Well, Chairman,
he might be right on that take, the whole fact-finding thing, but like, all right. Statements from witnesses. I believe the initial one I think even a statement from a witness is signed under some oath or under with the understanding that inconsistencies found will be used against them, or they can maybe. I'd have to look that up, but that'd take too much.
Murr, you said when you came up to the dais that you've heard the facts, and I would agree, we have not heard facts yet because no facts have been established. Are you aware of any transcripts or video recordings of witness interviews conducted under the auspices of the General Investigations Committee?
Yes.
Were those witness interviews?
The first question he answered outright. Thank God.
Transcripts or video recordings ever made available to the full membership of the Texas House of Representatives?
Importantly, the transcript from the multi-hour presentation by our retained attorneys and investigators was made available on our committee website and published and printed for all the members of this body.
Were there transcripts of the investigators interviewing witnesses?
Recordings were made of each interview.
Were those recordings made available to the membership of this body?
No, those are part of the investigatory process of the General Investigating Committee.
Chairman Murr, have the members of the full House been given the opportunity to ask questions to the persons hired by the General Investigations Committee to investigate Ken Paxton?
Oh, god damn it. They don't even have the decency of telling you when their ads are going to play.
Those questions were made by members of the committee, and I'll point out that our House rules for almost a decade have embodied the role of the General Investigating Committee to be the workhorse on investigation on behalf of the body, both in areas of concern around the state, as set forth in the government code, and specifically with respect to articles of impeachment.
Chairman Murr, will any member of the Texas House, as part of this proceeding, be able to ask questions to the persons who investigated Ken Paxton?
Right now, today, you have the report from the committee before you, and we have done that work on behalf of the committee, pursuant to the House rules, pursuant to the government code, and so we are providing that information to you.
As part of this proceeding today, will the members of this body be presented with any witness transcripts?
We have provided a transcript of the multi-hour hearing. The video is also available to you.
Were there any witnesses that testified in that hearing you're referring to?
No.
All right.
The video is also available to you.
Were there any witnesses that testified in that hearing you're referring to?
All right, so I just real quickly want to bring it here since, you know, everything is... I think I'll wrap it up with this particular thing because I don't want to... It's getting close to time and I don't want to be too hungry for too long. So, just gonna mute the sounds. I'll need to remind myself to unmute that. Andrew Murr, Ann Johnson, Charlie Guerin, Oscar Longoria, and David Spiller. Here are the jurisdictions of the General Investigative Committee. So, 13... Procedural. A, the committee shall have 5 members of the House appointed by the Speaker, shall be appointed in the chair and the vice chair of the committee. B, the committee has all the powers and duties of a General Investigative Committee and shall operate as the General Investigation Committee of the House according to the procedures prescribed by Subchapter B, Chapter 301 Government Code, and the rules of the House as applicable. The committee may begin work as soon as it desires after its members are appointed. The committee shall meet, organize, and adopt rules of evidence and procedures and any other necessary rules. The committee rules may not conflict with the Section 301.025 Government Code. B2. Whether or not the legislature is in session, the committee may meet at any time or place in the state determined necessary by the committee. B3. If the committee decides not to conduct joint hearings as provided by Section 301.019 Government Code, the committee shall establish a liaison to hold on. Just gonna pop this back here for better reading. Where was I? Liaison to fully inform the chair of the Senate Committee of the nature and progress of an inquiry by the other committee. B4. On a majority of vote, the committee may conduct joint hearings and investigations. B5. Committee may 1. Investigate or continue inquiries and hearings concerning A. State governments. B. An agency or subdivision of government within the state. C. The expenditure of public funds at any level of the government within the state. And D. Any other matter the committee considers necessary for the information of the legislature or for the welfare and protection of state citizens. And 2. Inspect the records, documents, and files and may examine the duties, responsibilities, and activities of each state department, agency, and officer in each municipality, county, or other political subdivisions of the state. B6. If a person disobeys a subpoena or other process that the committee lawfully issues, the committee may cite the person for contempt and cause the person to be prosecuted for contempt according to the procedures prescribed by subchapter B, chapter 301, Government Code, or by other law. B7. The committee shall report to members of the legislature that the committee make reports to members of the legislature that the committee determines are necessary and are appropriate. B8. Information held by the committee that, if held by a law enforcement agency or prosecutor, would be accepted from the requirements of 552.021 Government Code under section 552.108 of that code is confidential and not subject to public disclosure. B9. If for any reason it is necessary to obtain assistance in addition to the services provided by the state auditor, attorney general, Texas Legislative Council, or Department of Public Safety, the committee may employ and compensate assistants to assist in investigation, audit, or legal matter. C. Yeah, that's B. That's where all the B's. C. The committee may investigate a matter related to misconduct, malfeasance, abuse of office, or incompetency of an individual or office under Chapter 665 Government Code. Committee has all the powers and duties conferred by the chapter for the purposes of conducting investigations, including the authority to propose articles of impeachment. D. The committee has original jurisdiction over the receipts, processing, investigation, and resolution of complaints relating to appropriate workplace conduct under Rule 15, housekeeping resolution, and policies adopted by the Committee on House Administration. If a complaint relates to the conduct of a member of the committee, the member's employee, or an individual related to the member or the member's employee within the third degree by consanguinity, or within the second degree of affinity, or second degree by affinity as determined by Chapter 573 Government Code. Number 1. The members shall not participate in any committee proceeding related to the complaint, and 2. The speakers shall designate a member of the House drawn by lot under subsection E of the section to act in the place of the disqualified member. The designation of a member under the section in subsection ends when the committee makes its final disposition of the complaint. So the committee has original jurisdiction. As a member of housekeeping, if a complaint relates to a conduct of a member of the committee. So if in the General Investigation Committee, one of the members, their employees, or an individual related to the employee, or the employee's or member's employee within third or second degree relationship, they are to be removed from that committee until that investigation ends. E. When a member of the committee is disqualified, but under subsection D of the section, the chief clerk shall prepare a list of the current qualified members of the House, omitting the names of the speakers, the disqualified member, each other member of the committee, and any member elected from the same county as a disqualified member. The chief clerk shall write on a separate piece of paper of a uniform size and color the name of each member that appears on the prepared list. The chief clerk shall deposit the piece of paper in an opaque container that is designed to permit the random distribution of the pieces of paper after the initial deposit, and to prevent the viewing of any of the pieces of paper at any time. After the pieces of paper are randomly distributed, the sergeant in the container, The sergeant at arms shall draw a single piece of paper and deliver that piece of paper to the chief clerk. The chief clerk shall inform the speaker of the name drawn by the sergeant of arms for designation under subsection D. This is the jurisdiction of the General Investigation Committee. And if you haven't learned anything from any of this at all, understand this that I have learned right now, right here. Government and the powers and responsibilities of governance is a fucking headache. And lawyers who learn how to read and interpret and talk about all these things should be commended in only that aspect before being thrown off a cliff because they are lawyers. With that said, thank you for coming to the show. I am done with this topic for today, and I will continue the topic tomorrow when I finish that video about the Kim Paxton impeachment, the questions therein, and hopefully I shall get a Texas lawyer or a prosecutor to talk about the processes, because if I remember right, an investigation, even statements under an investigation are, you know, maybe a little bit sworn with fear of perjury. They did that with Gage Grosskreutz, and he had to sign a thing that said, hey, if I lie after this, I have perjured myself. But that's in Wisconsin. What do I know? I'm just a guy. With that said, before I wrap everything up, for real this time, go to Dragon's Treasure and use code Layman at checkout for 10% off your purchase. It's a haven for anime and tea lovers, and they are now selling coffee. And I plan on getting in on that coffee. I have the Dio coffee pre-ordered, and I will be drinking that next time, or whenever I get it. And hopefully, I'll be able to give good reviews, because I trust that the Tea Man, now turning into Coffee Man, has made a pretty good product. That said, I'm going to start wrapping up. Thank you for watching. What? Hold on. Say again? The tea? You fucking what, mate? This is why I stream when I'm alone. I don't got some peanut gallery fucker off to the side going, oh, that was dumb. I get that from the audience. If you want to say that, say it in the comment section or the chat. God damn it. Anyway, thank you for watching. Remember to like and follow on Rumble and on YouTube. I have a gaming channel. Please go and follow that as well, because that is what I do on the days where I am not very interested in the law topics and I just want to relax and also provide some content to everybody. I'll still be wearing my stupid blue shirt, and I got a couple more, a stupid blue shirt or stupid white shirt, because I find the dress to be interesting and it makes me feel like I'm actually presentable for a stream. But that said, remember, like on YouTube and on Rumble, the gaming channel, everything can be found in the description. On the YouTube side, I have everything linked in channels, in the channel subsection. And on Rumble, they don't have that feature yet, but it's in the comment or in the description below. Please go and find that. It's also where you can find the Dragon's Treasure, and you can and it has the link. I should probably post a link tree instead of all the links that I have, so it's all organized and you just click on it and you go. I'm on Twitter at Legal Layman with 2 N's at the very end of the name. You can find me on Backed.by, which is a blockchain Patreon that is done by Dick Masterson. They have helped. They're actually pretty good at the whole customer service. They got me set up. I had a bit of troubles at the start. They got me sorted out. I'm set on that end. Or you can find me at legallayman.locals.com, which is like Patreon in the more accurate sense, with the credit card, bank payment statements, whatever. But it is not like Patreon in the fact that they won't cut your account because of off-platform speech. So there's that. With that said, remember to like and subscribe. It helps a lot. I appreciate everybody who joined to watch. Now, I hope to see you guys next time. And thank you for anybody who comes to watch on the replay. It means the most. I hope to see you guys next time whenever I listen to a bunch of people speak and I try not to let my brain exit my ear holes like I did this time, and I got distracted while listening to one of the committee members speaking. With that said, thank you for watching. I hope to see you guys next time. Hang loose.